Today, we're going to talk about reducing income tax. This is an issue that high-income taxpayers are really interested in. Recently, we talked about the issue of moving to a permanent residence. This can be seen as a part of that. It's about the safe harbor, which is a safeguard that recognizes you as a non-resident of a state while you're away from that state. I will explain the safe harbor regulations of the two states, California and New York, where many clients actually end up disputing over tax residency issues. Alright, before we get started, this channel provides professional information on U.S. law, tax law, and financial planning. Not only this video, but we will continue to upload more beneficial content in the future. I hope you don't miss out. To do so, if you haven't subscribed yet, please subscribe and also make sure to like the video. I hope the video gets 15% likes. The reason why the safe harbor rule is important is because whether or not you are considered a resident under a particular state's tax law makes a significant difference. If you are considered a state resident, it means that regardless of where you earn your income, that state has the authority to tax you. So, for example, if I am a resident of California, whether I earn money in Korea, Texas, or any other state, I will be taxed by California. Moreover, California has high taxes, meaning the tax rates are high. So, if you weren't a resident, at least you wouldn't have to worry about being taxed by California on income earned in other states or countries unrelated to California. But since you are a California resident, it becomes an issue. And here, as mentioned before, there are various, dummy missiles. When talking about my permanent residence, it's determined by facts and circumstances, right? Like a driver's license, voter registration. There are various things like this, and these things exist. Ultimately, there's a safe harbor, meaning if you meet certain conditions, you'll be considered a non-resident, even if there are still such elements elsewhere. It's like saying they'll overlook it. In the United States, it's a high-tax state. States like California and New York tax worldwide income. Ultimately, whether you receive dividends in Korea, sell stocks in Japan, or sell a building in another state. If you are, for example, a California resident, California state tax is imposed on all of that income. So, high net worth individuals or workers dispatched overseas might want to claim, "Oh, I'm no longer a resident of this state." On the other hand, from the state government's perspective, as much as possible, no, you're still a resident. So, they would still consider you a resident of that state and tax you accordingly, leading to a back-and-forth situation. However, what helps avoid this kind of hassle is what we call the safe harbor rule. In other words, from the state government's perspective, if you meet certain conditions, they will say, okay, we won't go into the facts and circumstances, and we'll recognize you as a non-resident. So, even if there are some lingering elements of domicile, if you satisfy the safe harbor, they will treat you as a non-resident. Now, not all states have a safe harbor provision. The states that typically have it, where many Koreans also reside, are California and New York. Today, we will look into the system of these states. First, let's start with California. California's safe harbor requires meeting 3 main conditions. The first condition is that you must relocate and stay overseas or in another state for employment purposes. This is known as an employment-related contract. So, you need to leave California due to employment. And the second condition is 546 days, which is almost a year and a half. The second condition is that you must stay outside of California for at least a year and a half. Additionally, during this period, there is a condition that you must not exceed a total of 45 days visiting California. The third condition seems to be not well known. There is an income condition. What is the income condition? You must not have intangible income. Intangible income refers to income such as interest, dividends, or capital gains from stocks, and if this type of income exceeds $200,000, the safe harbor cannot be applied. Additionally, it states that you must not have any income sourced from California. That's the third condition. So, it's not enough to simply have been abroad for 18 months. There are also considerations regarding the number of days stayed. Of course, it also has to be due to an employment-related contract, and there are restrictions on income, so you must meet all these to be recognized as a non-resident. This was California's safe harbor rule. Alright, let's take a quick look at an example. This is a case recognized as the first safe harbor in California. For instance, if AC was working in California and then was dispatched to the Korean branch, and it is expected that they will be there for more than a year and a half. So, in reality, they reside there continuously for more than a year and a half. During that period, the total number of days visited in California was 30, and the intangible income, such as interest, dividends, and stock transfers, was $18,000 annually. Also, what if there was no income source from within California? All the requirements are met. So, the safe harbor applies and they are recognized as a non-resident. So, despite any other facts and circumstances, such as having a car, a bank account, or immediate family still residing in California, California would still recognize you as a non-resident. Now, let's look at the second case. In the case of BC, they were also dispatched to Korea, and let's assume they stayed for more than 18 months. However, they own an apartment in California. Let's say they own rental property, and let's assume they earn $36,000 a year in rental income from it. Then, as mentioned earlier, there is income sourced from California, and this ultimately means that they do not meet the income conditions, so the safe harbor cannot be applied. Does the inability to apply the safe harbor mean that this person is considered a resident of California? That's not the case. If the safe harbor is not met, it is more accurate to say that it moves to the basic rule, which is to assess based on facts and circumstances. So, that was California up to this point. Now, let's take a look at New York. New York is a bit easier. You could say it's a bit less strict than California. Let's take a look at the details. Compared to California, the advantage is that it's a more clearly defined, number-based test. But the downside is that even if you meet the safe harbor, some basic facts and circumstances can still apply. What this means is, under the safe harbor rule, first, it's 548 days. Well, it would still be a year and a half, but you must reside outside of New York. And during that period, the number of days you stay in New York must be 90 days or less. This means that you must actually reside outside of New York for more than 450 days. Unlike California, there are no conditions regarding intangible income or any income source from California, and there is no condition that you must leave for employment-based reasons. In other words, if you meet these safe harbor requirements, New York will recognize you as a non-resident, even if there are still elements of domicile remaining. However, as mentioned earlier, the difference with New York is that even if you meet the safe harbor, if it is determined through other facts that your permanent intention is to reside in New York, this can still be denied. Then why? Is it called a safe harbor? You might ask. New York's stance is that. The stance of New York law is that. It's a kind of presumption. It's an assumption. This means that the safe harbor is not an absolute determination. In other words, even if the IRS sees that the safe harbor requirements are met and generally considers someone a non-resident, if there is strong evidence that it was done only formally, and the person actually intends to continue residing in New York, then this safe harbor could be broken. Ultimately, it would be correct to say that they take the stance of substance over formality, meaning that the actual substance is more important than the formal requirements. So, for example, even if I meet the safe harbor requirements in New York, if my spouse and children are still residing there, and the taxpayer has a fixed residence and frequently comes and goes, and if things like a driver's license, bank accounts, or health insurance are all kept in New York, then the state tax authorities might argue that although the formal residency requirements are met, substantively, isn't there a domicile in New York? That's the kind of argument they could make. Substance must accompany it. Otherwise, the shield is not complete. Consider an example from New York. There's a person named CC. They were dispatched to Singapore for 2 years. Now it's been 18 months. They spent 60 days in New York. It's under 90 days satisfied. And since they actually resided outside of New York for more than 520 days. And here, it also mentions that the family relocated together. Then it means that the safe harbor rule is satisfied, and it is also recognized that they are practically disconnected from New York, thus acknowledging them as a non-resident. Now, looking at a second case where the safe harbor is not applicable. In the case of DC, they resided overseas for 18 months, and although the visit days were barely within 80 days, they still met the requirements. However, their spouse and children were in New York, and they maintained all connections such as residence, bank, and driver's license. If it can be shown as a fact that they kept coming back to New York during every vacation, then apart from meeting the formal requirements of the safe harbor, there is a possibility they could be considered a substantive resident and thus excluded from the safe harbor. So to summarize, in the case of California, the safe harbor is quite conservative, but let's say it involves employment-related matters and income restrictions. And although there are these limitations, if the safe harbor is met, it can be seen as relatively more favorable in terms of other facts and circumstances. New York only has regulations based on the number of days stayed, so at first glance, it seems more generous and easier to meet, but it can still be challenged during an audit depending on actual residency. Ultimately, that means to make good use of the safe harbor, you need to meet the formal requirements well. At the same time, you shouldn't be complacent about the facts and circumstances either. Today, we looked into how, in relation to state residents, especially in high-tax jurisdictions like New York and California, by meeting the safe harbor requirements, we can gain a favorable position in determining residency or non-residency, and what that entails. That's it for today. I hope today's content was helpful. There must be many people around you who need this kind of information. This channel is a space for growth together with you. Please subscribe and like so you don't miss out on essential information next time. I ask for your help in ensuring this information is well conveyed to those around you. Thank you.